This is an IEEPA Tariff Refund Recovery Public Information Campaign by Tariff Recovery Group USA. Visit tariffrecoverygroupusa.com for additional information about claiming your tariff refund or to apply for a cash advance on a claim that you have already filed. You've probably heard that 37% of IEEPA entries are stuck outside of the CBP's CAPE portal, completely unable to be refunded. This was money that the Supreme Court had already ordered to be refunded to businesses, but which simply wasn't reachable through CAPE. But now there's finally some good news. Most of that previously unreachable 37% has now been unstuck, so to speak, by a new CBP processing phase, which launched on June 29th, and which now allows that money to finally be refunded by filing for it through the CAPE portal. Unfortunately, it's not all good news, because there's still a slice of finally liquidated entries not included in CBP's new processing phase, and these are the ones that still need the help of a customs and trade attorney to access. The problem is that you may now assume that all of your entries are fully covered, when they're not. For businesses that need the help of an attorney, a deadline is running on each of those entries, and as of now, only a fraction of the eligible businesses have actually taken the one legal step that could protect their full claim. In this video, I am going to briefly explain two things that you need to know about this newly launched processing phase. Firstly, how to know whether or not all your entries are actually covered by this new phase, or whether some of them have fallen through a gap that most people don't know about. And secondly, how to reach the portion of your entries which still remain out of reach of CBP's CAPE portal in order to recover your full refund of those tariffs. So what happens to the roughly 37% of IEEPA entries that Phase 1 doesn't cover? Phase 2, which launched on June 29th, now covers most reconciliation entries, being about $28.7 billion worth of tariff refunds. Then what is actually left after that is all the finally liquidated entries, being only about 7% of total IEEPA payments, or roughly $11.4 billion in total, which need a lawsuit to be filed at the Court of International Trade before CBP can refund them. The 37% of entries which Phase 1 doesn't cover isn't only one type of entry, but rather a few different things all lumped together, namely reconciliation entries, some anti-dumping and countervailing duty entries, and finally liquidated entries. Phase 2 specifically resolved the reconciliation entry chunk of that, the biggest single piece that was sitting unreachable. But here's the trap that you could still fall into. If you filed reconciliation entries before May 2025 on the standard cycle, they may have already liquidated more than 80 days before Phase 2 opened. This means that some of those entries could still fall outside of Phase 2. What's left after Phase 2 are the finally liquidated entries, that roughly 7% figure, which are the entries still unreachable via the CAPE portal. Much smaller than the headline 37% number that gets thrown around, but this is the part that still needs a lawsuit to file for. In a recent court hearing, CBP has said that Phase 3, which is targeted for late July, will only process refunds for importers who've already filed suit at the Court of International Trade. Filing suit isn't just a last resort anymore, but rather it is the officially confirmed pathway for CBP's Phase 3 system launching later this month. And that 2-year deadline to file a lawsuit has been running from the liquidation date, all regardless of when Phase 3 actually launches. Here's the number that should concern you. Only about 4,000 eligible U.S. importers have actually filed suit at the CIT so far, out of an estimated 330,000. That's a little over 1%. If you're waiting to see what happens before you act, you're in the overwhelming majority, and that group is running out the clock on a deadline that doesn't wait for anyone. If you miss it, those entries aren't simply delayed. Instead, they're gone, permanently forfeited. Let's bring this all together now in a very quick recap. CBP has confirmed a real timeline. A second wave of processing, covering reconciliation entries, launched on June 29th. A third wave, covering finally liquidated entries, is targeted for late July. But that third wave only applies to importers who've already filed suit at the Court of International Trade. In other words, filing the lawsuit isn't just your only option if you miss the deadline. For many importing businesses, it's about to become the key that unlocks the rest of their refund. If you imported goods subject to IEEPA tariffs between February 2025 and February 2026, you likely have a legitimate claim. Filing windows are closing. The first step is independent assessment of your complete import history, not just the entries that happen to be easiest to process, so you can know now if an attorney is needed to recover your full tariff refund. This has been part of an IEEPA Tariff Refund Recovery Public Information Campaign. For all the up-to-date information about how to collect your refund of unconstitutionally collected IEEPA tariffs and to check if your business qualifies, visit tariffrecoverygroupusa.com, where you can file your valid refund claim today with the full backing of an independent, nationally ranked U.S. Customs and Trade law firm. There is no upfront cost to file your claim, and if you have already filed, regardless of how the filing was done, we offer a way to get a cash advance on your refund within just 5 to 10 business days, not by waiting months or years. Check your eligibility for free and without obligation today at tariffrecoverygroupusa.com. It costs nothing and takes only a few minutes. Link in the description and pinned comment.